Typing is an essential after dictation. Read dictation materials. Subscribe to get contents via mail. Purchase shorthand journals and more.
The law regarding the nature, scope and value as a piece of evidence of oral and written dying declarations is now fairly well settled by various judicial decisions of this court. A dying declaration, oral or written, before it could be relied upon, must pass a test of reliability, as it is a statement made in the absence of the accused and there is no opportunity to the accused even to put it through the fire of cross-examination to test its genuinity or veracity. The court has therefore to subject it to close scrutiny. But once the court is satisfied that it is a truthful version as to the circumstances in which the death resulted and the persons causing injuries, the law does not expect that there should be corroboration before it can be relied upon. However, if there are infirmities and the court does not find it safe to base any conclusion on it without some further evidence to support it, the question of corroboration arises. We may refer to one of the decisions of this court in the case wherein in para 3 this court observed as under. An oral dying declaration no doubt can form the basis of conviction, though the courts seek for corroboration as a rule of prudence, but before the said declaration can be acted upon, the court must be satisfied about the truthfulness of the same and that the said declaration was made by the deceased while he was in a fit condition to make the statement. The dying declaration has to be taken as a whole, and the witness who deposes about such oral declaration to him must pass the scrutiny or reliability. The whole idea of accepting a statement in the name of dying declaration comes from a maxim which means that a man will not meet his maker with a lie in his mouth. It is believed that when a man is at the point of death and when every expectation of this world is gone, it hushes away every motive of lie. In our view, the oral evidence of the PW2 is quite natural. On the day of occurrence, he was working in his agricultural field. His presence in his field could be said to be natural. There is no good reason for PW2 to come before the trial court and depose falsely against the accused persons. It is not even the case of the accused appellant, herein that PW2 had some acts to grind against him, including to other co-accused, and therefore fabricated the entire story of an oral dying declaration. Besides the same, the oral dying declaration of the deceased made before PW2 stands corroborated with the medical evidence on record. The medical evidence on record would suggest that there were 75% burn injuries on the chest of the deceased. The burn injuries were suffered by the deceased as the accused persons are said to have poured hot lally, raw material used for preparing liquor.